immigration agenda, his crackdown, he signed into law on the first day in office. And it's not the first time that the Supreme Court will look at this issue. You remember just about a year ago, the Supreme Court heard a case involving the president's attempt to end birthright citizenship. But at that time, the justices were squarely focused on whether individual courts around the country could block the order while the litigation continued. They ultimately said that nationwide injunctions were not okay, but judges found ways around them. That executive order remains on hold. Birthright citizenship is still the policy of the land, but now the president is back to the Supreme Court asking them to decide this issue on the merits, even though, as you mentioned there in the intro, more than 100 years of legal precedent has established and reaffirmed that the Constitution does in fact spell out that anyone born on American soil is an American. And what the justices said this—
You just heard it, and now let me tell you exactly what we're watching here. Because this is not some procedural question about legal technicalities or some dry debate about constitutional interpretation. This is the wholesale rewriting of who gets to be an American happening in real time, before our very eyes, and the Supreme Court just agreed to let Trump try to erase birthright citizenship, a constitutional guarantee that has stood for more than a century and a half. And if you think this is just about immigration policy, then you haven't been paying attention, because what we're witnessing is nothing less than the systematic dismantling of the 14th Amendment by executive decree, with a complicit judiciary that seems perfectly willing to entertain the possibility that a president simply wish away constitutional protections with the stroke of a pen. The Supreme Court on Friday said it will hear arguments in a case that will determine if President Donald Trump can undo automatic citizenship for people born in the United States, and let that sink in for just a moment, because we are talking about overturning birthright citizenship that was added to the Constitution in 1868, when the 14th Amendment was adopted following the Civil War to overrule the Dred Scott decision, one of the most shameful moments in American jurisprudence when the Supreme Court declared that black people whose ancestors were enslaved could never be citizens, and the 14th Amendment was the moral and legal response to that horror, the promise that this nation would never again create a permanent underclass of people born on American soil who were denied the full rights of citizenship. And now here we are in December 2025 with lower courts made up of both conservative and liberal judges that have all sided against the administration's order. Every single federal judge who has examined this question has found Trump's executive order unconstitutional, or likely unconstitutional. 4 federal courts and 2 appeals courts have blocked implementation of the executive order, and yet the Supreme Court with its conservative supermajority is taking up the case anyway, preparing to hear oral arguments early next year that could fundamentally redefine what it means to be American. And I want you to understand the stakes here, because states and others challenging the executive order have said in court filings that it could strip citizenship from hundreds of thousands of children each year, hundreds of thousands of babies born on American soil, who would suddenly find themselves stateless, without a country, without protection, without the most basic recognition of their humanity and their belonging. The correspondent in that clip mentioned that the order told federal agencies to refuse to recognize the citizenship of children born in the U.S. if their parents are undocumented or here on temporary visas, and think about the bureaucratic machinery of dehumanization that requires federal workers instructed to look at a newborn baby, a child who took their first breath on American soil, and say, "No, you don't count, you're not one of us, your birth certificate will be denied, your social security number withheld, your very existence as an American erased before you can even speak." This is the administrative apparatus of exclusion operating at its most insidious level, and if implemented, this policy would force all parents, including U.S. citizens, to prove their immigration status just to get a birth certificate or social security number for their baby, inevitably leading to racial profiling based on name's appearance or accent. So let's be absolutely clear about what we're talking about here. This isn't just targeting undocumented immigrants. This creates a regime where every parent, every family, every person seeking recognition for their newborn child will be subjected to interrogation about their papers, their status, their worthiness to have an American baby. Now I want you to pay attention to what the Trump administration is arguing here, because it reveals the intellectual bankruptcy and the historical revisionism at the heart of this entire project. Solicitor General D. John Sauer told the Supreme Court that the citizenship clause of the 14th Amendment was adopted to grant citizenship to newly freed slaves and their children, not to the children of temporary visitors or illegal aliens. And this argument is so profoundly ahistorical, so deliberately obtuse in its reading of constitutional text and precedent, that it would be laughable if it weren't so dangerous. Yes, the 14th Amendment was adopted to ensure citizenship for formerly enslaved people and their descendants, But the framers of that amendment didn't write narrow language that said only the children of formerly enslaved people. They wrote expansive universal language that said all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. And that word all is doing a lot of work there. It's not some persons or persons whose parents meet certain criteria. It's AL persons. And the phrase subject to the jurisdiction thereof has been understood for more than a century to exclude only the children of foreign diplomats, invading armies, and members of certain Native American tribes not subject to U.S. law. That's it. That's the exception. Legal scholars of all ideological stripes have generally assumed the phrase to be self-explanatory. And we don't have to speculate about what the 14th Amendment means, because the Supreme Court already decided this question in 1898, in United States v. Wong Kim Ark. And let me tell you about Wong Kim Ark, because his story is everything that Trump and his allies are trying to obliterate from American memory. Wong Kim Ark was a U.S.-born 24-year-old living in San Francisco, born to parents of Chinese descent, who successfully argued that the 14th Amendment granted him citizenship, and this case happened during the Chinese Exclusion Act, during a period of virulent anti-Asian racism when Chinese immigrants were explicitly banned from becoming naturalized citizens, and even in that hostile environment, the court by a vote of 6-2 rejected the government's argument that Wong Kim Ark was not a U.S. citizen because the Constitution's text was clear, because birthright citizenship was not some policy preference, but a fundamental constitutional guarantee. For over a century since a young Chinese-American cook from San Francisco named Wong Kim Ark won his case at the Supreme Court, birthright citizenship for all, including babies born to immigrants, has been a cornerstone of U.S. democracy, and now Trump wants to throw all of that away, wants to pretend that 127 years of settled law and practice can simply be erased. But here's what makes this moment so terrifying. Here's the bombshell that should have every person who cares about democracy and the rule of law absolutely alarmed. The Trump administration told the Supreme Court that the understanding of the citizenship clause enshrined in the 1898 opinion was mistaken and had destructive consequences. They are openly arguing that Wong Kim Ark was wrongly decided, that more than a century of precedent should be overturned, and Trump, as part of his immigration crackdown, has sought to unravel that historical understanding, embracing a hitherto fringe theory pushed by anti-immigration activists. This is a fringe theory. This is not mainstream legal interpretation. This is the kind of argument that has been floating around in the fever swamps of nativist activism for decades, rejected by serious legal scholars across the ideological spectrum. And now it's getting a hearing before the highest court in the land, because Trump signed an executive order on his first day back in office, and a right-wing Supreme Court is apparently willing to consider whether the president can rewrite the Constitution. And let's talk about that Supreme Court for a moment, because we need to understand the institutional context here. The Supreme Court is stacked with a conservative majority that has generally supported Trump. This is a court that has been systematically dismantling precedent, overturning decades of established law, from Roe v. Wade to Chevron, deference to affirmative action. This is a court that has shown itself willing to embrace maximalist interpretations of executive power when it comes to Trump's agenda, and now they're being asked to gut birthright citizenship, to create what seeks to repeat one of the gravest errors in American history by creating a permanent subclass of people born in the U.S. who are denied full rights as Americans. The ACLU is absolutely right when they say this would create a permanent subclass, because that's exactly what it would do. It would create a caste system where your citizenship status, your very recognition as a human being worthy of legal protection, depends on the immigration status of your parents, depends on factors entirely beyond your control determined before you were even born. Now I want you to understand the procedural gamesmanship that got us here, because it's revealing about how the Trump administration and the conservative legal movement operate. Earlier this year, the court sided with Trump on technical grounds dealing with how the challenges to the policy were handled by lower courts. They didn't rule on the merits of whether birthright citizenship could be ended. They ruled on whether federal judges could issue nationwide injunctions blocking the policy. In June, the court split 6-3 to side with the administration in that procedural case, which didn't address the underlying legality of Trump's proposed citizenship restrictions, and Justice Sotomayor in her dissent called out this procedural manipulation for what it was. Justice Sonia Sotomayor wrote on behalf of the trio of Democratic appointees that for the government to win on the merits of the citizenship issue, it would have to show that the order is likely constitutional, an impossible task, and she pointed out that the reason the Trump administration wasn't asking the court to rule on the merits back then was because they knew they would lose. They knew that the constitutional case against them was so strong that even this conservative court might not be willing to go along. So instead they played procedural games, they got the court to limit nationwide injunctions, and then they came back asking for the merits to be decided. But here's something that should give us a glimmer of hope even as we steel ourselves for the fight ahead. Even though the court has been siding with the administration on several Trump policies in his second term, there is some reason to doubt that the court will go along with the government on this one. And indeed, the Trump Justice Department's litigation strategy suggests some doubt within the administration about how the justices will rule. Think about that. Even Trump's own lawyers seem uncertain about whether they can win this, rather than rush for a high court ruling to reverse those losses on a key executive priority. The administration launched a half measure, a procedural appeal to curb the use of nationwide injunctions, rather than urge the justices to immediately deem the underlying policy lawful. And that tells you something about how weak their legal position is, how far outside the mainstream of constitutional interpretation they're operating. And every legal expert, every civil rights organization, every person who has studied this issue knows that Trump's order is unconstitutional. The American Civil Liberties Union and other groups told the Supreme Court that their case amounts to little more than a jumble of historical misstatements, inapposite citations, newly manufactured doctrines, and more than anything else policy preferences. And that's exactly right. This isn't legal reasoning. This is policy preference dressed up in constitutional language. This is the Trump administration deciding they don't like birthright citizenship because it conflicts with their nativist immigration agenda, and then working backwards to manufacture a legal justification no matter how tortured or ahistorical. Civil rights groups argued in a brief before the Supreme Court that review was unwarranted because the key question was already resolved, citing the decision in the 1898 Wong Kim Ark case, which is one of the most important decisions in our nation's history and stands as a cornerstone of our modern society. And they warned that reopening questions of birthright citizenship would cause potentially catastrophic effects rippling out far past the particular order at issue here. Let me tell you about those catastrophic effects because this isn't abstract constitutional theory. This is about real human beings, real families, real children whose lives hang in the balance. The Trump administration's order seeks to deny citizenship to children unless one of their parents is a U.S. citizen or has permanent immigration status, excluding children born to parents on temporary work student or other visas or without immigration status at the time of birth. So we're talking about children born to people on student visas, on work visas, on tourist visas, people who are here legally but temporarily, not just undocumented immigrants, and suddenly their American-born children would be rendered stateless. Think about what that means. A baby born in a hospital in New York or California or Texas, a baby who has never known any country but America, would be denied citizenship, denied a social security number, denied a birth certificate, denied access to basic services and protections. Removal of birthright citizenship would put people born in America in a state of statelessness, which is one of the most vulnerable conditions a human being can experience, to be a person without a country, without legal standing, without protection under any nation's laws. And we need to talk about who this targets, because the racism at the heart of this policy is not subtle, it's not hidden, it's right there on the surface for anyone willing to see. Trump is posing the question of who gets to be an American to our nation. And given that today's migrants are from Africa, Asia, the Caribbean, and Latin and Central America, it is clear he is questioning who are the right people to benefit from birthright citizenship. Representative Pramila Jayapal nailed it when she said this, because that's exactly what's happening here. This is about Trump and the nativist right deciding that certain kinds of people from certain countries, people with certain skin colors, don't deserve to have American children, don't deserve to be part of the American story. Emboldened by a Supreme Court that would use its power to uphold white supremacy rather than the Constitution of our nation, Trump is on a mission to weaken the very soul of our nation. And that is not hyperbole, that is a sober assessment of what we're watching unfold. This policy would create a two-tier system where some babies born in America are citizens, and others are not, based entirely on the legal status of their parents, and by creating an unlawful regime where some American babies are treated as second-class citizens based on their parentage. The Trump administration is taking a sledgehammer to the foundations of that society. And think about how that would work in practice. Think about the enforcement mechanisms required. Every hospital, every state vital records office, every federal agency would need to start investigating the immigration status of parents before issuing birth certificates, before recognizing citizenship, and you know exactly what that means. That means racial profiling. That means demanding papers from parents who look or sound foreign. That means subjecting Asian American families, Latino families, Black immigrant families to additional scrutiny and suspicion that white American families would never face. This effort to demonize brown and black immigrants targets all immigrants in this country regardless of their background, as Juan Proaño of LULAC pointed out, because once you create a system where citizenship is conditional, where some babies born here need to prove their worthiness, everyone becomes suspect, everyone becomes subject to interrogation. And let's be absolutely clear about the historical parallel here, because the Trump administration wants us to forget, but we must remember. The 14th Amendment was ratified in 1868 specifically to overturn the Dred Scott decision of 1857, which held that a black person whose ancestors were brought to the United States and enslaved was not entitled to any protection from the federal courts because he was not a U.S. citizen. That was the legal regime before the 14th Amendment, a regime where citizenship was racialized, where being born on American soil wasn't enough if you were black, and the 14th Amendment was adopted precisely to ensure that could never happen again, to establish the principle that birth within the territory confers citizenship regardless of the status or characteristics of one's parents. And now Trump wants to take us back to a pre-14th Amendment understanding of citizenship, wants to reinstate a system where some people born here are citizens and others are not based on criteria determined by the government, and if that doesn't terrify you, then you're not paying attention. Donald Trump and Elon Musk will stop at nothing to enact their far-right agenda, including attacking the United States Constitution with an unprecedented assault on birthright citizenship and the 14th Amendment, as House Democrats wrote in their amicus brief. And that assessment is exactly right. This is an unprecedented assault. Never before has a president attempted to rewrite the citizenship clause by executive order. Never before has an administration argued so openly that a core provision of the Reconstruction Amendments should simply be ignored. And the amicus brief signed by 170 House Democrats provides overwhelming evidence that President Trump's executive order violates the Constitution and over a century of Supreme Court rulings as well as laws enacted by Congress, because this isn't just about constitutional interpretation. Congress has also codified birthright citizenship in statute. In 1940 and again in 1952, Congress passed laws that essentially enacted the Citizenship Clause into federal statute law, so Trump's order violates both the Constitution and federal law. But here's what makes this moment so dangerous. Here's the thing that should have us all organizing and mobilizing and preparing for the fight of our lives. This Supreme Court has shown itself willing to overturn precedent, willing to embrace radical reinterpretations of established constitutional doctrine, willing to privilege originalist interpretation that somehow always seems to lead to conservative policy outcomes. They overturned Roe. They gutted the Voting Rights Act. They eliminated affirmative action. They've systematically dismantled the regulatory state, and now they're being asked to overturn Wong Kim Ark, to declare that birthright citizenship was a mistake, and we cannot assume that they will do the right thing. We cannot assume that the weight of precedent and the clarity of constitutional text will be enough. The Supreme Court agreed Friday to decide if President Donald Trump's attempt to end birthright citizenship with an executive order is constitutional, offering the justices an opportunity to revisit what has widely been considered settled law since the 19th century, and the fact that they're taking this case, the fact that they're willing to entertain these arguments, tells you everything you need to know about how precarious our constitutional protections have become. And we need to understand this in the context of Trump's broader immigration agenda, because birthright citizenship is just one piece of a massive authoritarian project to redefine who belongs in America. The birthright citizenship order, which Trump signed Jan. 20, the first day of his second term, is part of his Republican administration's broad immigration crackdown. Other actions include immigration enforcement surges in several cities, and the first peacetime invocation of the 18th century Alien Enemies Act. We're watching the deployment of military force for immigration enforcement. We're watching the revival of laws from the 1700s to deport people without due process. We're watching the systematic construction of a deportation machine designed to terrorize immigrant communities and remove millions of people from this country, and the elimination of birthright citizenship fits perfectly into that project, because it creates a whole new category of deportable people, babies born on American soil, who are nonetheless defined as foreign, as deportable, as unwelcome. Think about the intergenerational trauma that this would create. Think about the families that would be torn apart. Think about the children who would grow up knowing that their government, their country, the place where they were born denies their very right to exist as Americans. This order will stigmatize and send a message of exclusion, not only to children directly impacted by the order, but to many others who will have their citizenship questioned because of their race, or who their parents are. And that's the insidious thing about policies like this. Even people who ultimately have their citizenship recognized will be subjected to suspicion, to additional scrutiny, to the constant demand to prove their belonging in a way that white Americans never have to prove theirs. This is how racism operates in policy, not just through direct exclusion, but through the creation of systems that mark certain people as perpetually foreign, perpetually suspect, perpetually less than fully American. Now let me tell you what happens next, because we need to be prepared for the legal and political fight ahead. Oral argument will likely be scheduled for next spring and decided by the end of June, so we're looking at Supreme Court arguments probably in February or March, and a decision by late June or early July 2026. And in the meantime, after the Supreme Court's decision, Trump's birthright policy was quickly blocked again by courts using other methods and has never gone into effect. So right now, at this moment, birthright citizenship is still in effect. Children born on American soil are still recognized as citizens, but that could all change next summer, and if this Supreme Court rules in Trump's favor, then we will have fundamentally transformed what it means to be American. We will have created a new regime of citizenship based not on birth within the territory, but on the legal status of one's parents. And I want to emphasize something that cannot be said enough. Every lower court that has looked at the issue has concluded that Trump's order violates or likely violates the 14th Amendment. Every single federal judge who has examined this question has found against the Trump administration. Conservative judges and liberal judges alike have looked at the constitutional text, looked at the precedent, looked at the statutory law, and concluded that this executive order is unlawful. That's remarkable. In our polarized age, where federal judges appointed by different presidents often reach diametrically opposed conclusions on controversial questions, on this issue there has been unanimity, universal recognition that Trump is trying to do something that the Constitution does not permit. And yet here we are with the Supreme Court agreeing to hear the case anyway, agreeing to consider whether all these lower court judges got it wrong, agreeing to potentially overturn 127 years of precedent. This is the stakes of judicial capture. This is what happens when you pack the courts with ideologues who are committed to a particular political project rather than to neutral principles of law. This is the fruit of the Federalist Society's decades-long campaign to reshape the American judiciary in service of conservative movement goals, and we cannot separate the birthright citizenship case from the broader pattern of this court's jurisprudence, from their hostility to immigrant rights, from their embrace of expansive executive power when it comes to immigration enforcement, from their willingness to find creative ways to rule in Trump's favor even when the law seems clear. Just look at what's happened already in Trump's second term. The Supreme Court allowed the resumption of sweeping immigration stops in the Los Angeles area after a lower court blocked the practice of stopping people solely based on their race, language, job, or location. They're allowing racial profiling in immigration enforcement. They're giving Trump enormous latitude to pursue his deportation agenda, and now they're considering whether he can rewrite the citizenship clause. We need to mobilize, we need to organize, we need to make it politically impossible for the Supreme Court to gut birthright citizenship, and that means mass protest, that means legal resistance, that means every organization that cares about immigrant rights, civil rights, constitutional rights needs to be flooding the zone with advocacy and activism. Cecilia Wang, ACLU National Legal Director, said no president can change the 14th Amendment's fundamental promise of citizenship. For over 150 years it has been the law and our national tradition that everyone born on U.S. soil is a citizen from birth, and we need to defend that tradition, that principle, that constitutional guarantee with everything we have. This is not the time for moderation. This is not the time for cautious incrementalism. This is the time for principled resistance, for moral clarity about what's at stake. And let me tell you why this matters, beyond the immediate question of immigration policy, why everyone should care about this case, even if you're not an immigrant, even if you think you'll never be affected by these policies. Constitutional rights are indivisible. The principles that protect vulnerable populations are the same principles that protect all of us, and when you allow the government to create categories of people who are born here but not citizens, when you allow executive fiat to override constitutional text, when you allow the highest court in the land to overturn settled precedent in service of a nativist political agenda, you have fundamentally weakened the constitutional order that protects everyone. The 14th Amendment ensures that no politician can ever decide who among those born in our country is worthy of citizenship, and in the face of the Trump administration's threats, the 14th Amendment's protections continue to safeguard the rights of every person born in this country. That's what the ACLU says, and they're absolutely right. This amendment, this guarantee, this principle is what stands between us and a system where citizenship becomes a political football, where demagogues can decide who belongs and who doesn't, based on xenophobic whims. The historian and legal scholar will look back on this moment, and they will see it for what it is, a test of whether American democracy and the American constitutional system can withstand the authoritarian impulses of a president who has open contempt for legal constraints, who views the Constitution as an obstacle to be overcome, rather than a framework to be respected. They will see whether the Supreme Court, the institution charged with being the guardian of constitutional rights, chose to uphold those rights or to collaborate in their destruction. And we cannot be naive about the possibilities here. We cannot assume that the Constitution will save us, that precedent will save us, that the obviously correct legal answer will prevail, because this court has shown us who they are. They have shown us their willingness to embrace right-wing legal theories, no matter how fringe, their willingness to overturn precedent, no matter how settled, their willingness to privilege the policy preferences of the conservative movement over the demands of justice and equality. If the justices agree with the president, the court could overrule a right guaranteed by the U.S. Constitution and upheld by SCOTUS over a century ago. The court, if that happens, if they actually do this, then we will have crossed a constitutional Rubicon. We will have entered an era where fundamental rights enshrined in the Constitution's text can be swept away by executive order and judicial acquiescence, and that should terrify everyone, because if birthright citizenship can be eliminated, if the citizenship clause can be rewritten, then what constitutional protection is safe, what right is secure, what guarantee can we rely upon? The answer is none. The answer is that we will have moved from a system of constitutional government to a system where the only thing that matters is who holds power and what they want to do with it. So yes, this case about birthright citizenship is about immigration, but it's about so much more than immigration. It's about whether we're going to be a nation bound by law, or a nation where the powerful can simply ignore legal constraints. It's about whether the promise of equal citizenship, regardless of the circumstances of one's birth, will endure, or whether we will return to a hierarchical system where some Americans are more American than others. It's about whether the 14th Amendment, born from the ashes of slavery and civil war, ratified to ensure that this nation would never again deny the citizenship of people born on its soil, will survive, or whether it will be gutted by a right-wing Supreme Court willing to embrace fringe legal theories in service of a xenophobic political agenda. Those are the stakes. That's what we're fighting for. And when oral arguments happen in the spring, every person who cares about justice needs to be watching, needs to be organizing, needs to be making clear that we will not accept the erasure of birthright citizenship. We will not accept the creation of a permanent underclass of people born here, but denied citizenship. We will not accept the betrayal of the 14th Amendment's promise. This is the fight of our generation, and we cannot afford to lose.